The court has also pronounced death sentence on Eastern Security Network, which was the military wing of IPOB.
Nobody is going to trample on me. Nobody is going to trample on Nnamdi Kanu. Mazi Nnamdi Kanu is not a terrorist. He's a man that was pursuing change. To pursue a separate nation of yours is not a crime.
Show me the law. Show me the law. I want to show me the law. You don't know law. That is nothing new. You are nothing rubbish. Show me the law.
So from here, we are heading to the Court of Appeal. If the Court of Appeal disagrees with us, we head to the Supreme Court. But by God Almighty, Mazi Nnamdi Kanu is not going to stand convicted. Not at all. He's going to get overturned.
Ndị ọchịchị ka ihere m unu o, ka ihere m unu, ọkwụnụ ahụla ihe unu mere anyị o, ka ihere m unu. Asị m ka ihere m unu wo, ka ihere m unu, ọkwụnụ ahụla ihe unu mere anyị o, ka ihere m unu. Asị m ndị niile akpọrọ ndị ọchịchị n'ala Igbo, ihere mekwa unu. Ihere m unu. Ihere mechi unu niile. Ka ihe a na-akọdị ha. Iwu Naijiria nwa bụ nnọọ naanị mgbe ọ bụ onye Igbo ka ọ na-arụ ọrụ ọkụ ya. Iwu nwa na-achị Naijiria bụ nnọọ naanị mgbe onye Igbo danyere na ya ka ọ na-arụ ọrụ. Lekwa ihe na-eme n'obodo Naijiria niile ugbu a. Mana onweghị onye ugwu ekpenubere ikpe wee tụọ ya nga n'ogburu mmadụ ma ọ na. Ndewonu ụmụnne m ndị Igbo ndị ọma njem ọnụ, ekelekwa m unu. Ebe nsi ewetara unu ozi a bụ n'ụlọ ozi ndị sim.ha asịrị FM. Aka m bụkwa nwanne gị nwoke 042 Solex, onye akụkọ ụwa. Biko unu eweliwe ka m si wee bido ya bụ ihe onyonyo ka o si dị m n'obi. Imirikiti n'ime unu ndị na-esonyere anyị ka mgbe ụtụtụ ga-ahụla ka ya bụ ikpe Maazị Nnamdi Kanu si wee gaa tata. Anyị gosiri ya bụ ihe niile gara na ụlọikpe tata, makwa imirikiti n'ime ihe gara n'ụlọikpe tata mgbe onye ọkaikpe bụ Justice James Omotosho maliterela wee gụpụta ọtụtụ ihe ha gụpụtachara ha si na ha ji wee tụọ Maazị Nnamdi Kanu nga. Ma o nwere mgbe anyị megide mgbe ebidoro gụwazịa verdict bụ ikpe amara ya. Ndị ụlọ ozi Channels TV ndị anyị na-esonye ọ dịka gasị na amanka gasị na data ha gwụrụ agwụ ka ọ bụ na asị ha gbanyụọ ihe onyonyo. Ihe nchebu mgbe ahụ, mana amaghị m ihe mere. Mana ekwere m unu nkwa sị na anyị ga-ewetarịrị unu ihe niile gara na ya bụ ụlọikpe ka o si wee gaa. Ihe ozi ọbụla si na ya bụ ụlọikpe Federal High Court wee pụta na aga m ewetara ya unu. Ma n'agbanyeghị na ọtụtụ n'ime unu ahụla ya bụ ikpe ka o si wee gaa na ha bụ ndị ụlọikpe site n'ọnụ onye ọkaikpe Justice James Omotosho si na atụọla Maazị Nnamdi Kanu nga mkpụrụ ọka bụ nga ndụ ya niile. Dịka o si wee gụpụta ya bụ ihe, ọ sị na ụfọdụ n'ime ya bụ iwu nke ha si na Maazị Nnamdi Kanu dara bụ nke na-arụtụ aka na iyi ndụ ụjọ terorizm, na ihe kwesịrị ịbụ ntaramahụhụ ya bụ igbu onye ahụ egbu, mana ịma mmadụ ikpe ọnwụ bụzi ihe imirikiti n'ime mba ụwa na-agbarụrụ iru, na ọ bụghịzi ihe a na-ekwute na ntị, na maka nke ahụ na a ga-atụzi ya nga mkpụrụ ọka. Unu mara na aka mgbe ụtụtụ ọtụtụ ihe onyonyo efegharịala ma ebe Maazị Nnamdi Kanu na-aba mba, ma ọtụtụ ihe gara na ya bụ ụlọikpe. Mana ihe onyonyo a achọrọ m ndị niile na-ekiribeghị makwanụ chọrọ ịhụ ka ya bụ ikpe si wee bido wee ruo mgbe Maazị Nnamdi Kanu malitere bawa mba, ihe butedịrị o ji wee bawa mba. Ihe onyonyo a ga-egosi gị ihe ahụ niile. Naanị wetuo obi ma tọọ ntị n'ala, maka na ya bụ ihe onyonyo ga-eto ogologo, mana isoro ya ị ga-ahụ ka ya bụ ihe si wee megide wee ruo mgbe Maazị Nnamdi Kanu bawaziri mba, wee ịhụ ka esi wee chụpụzie ya na ya bụ ụlọikpe. Maka na ọ bụ ya bụ onye ọkaikpe James Omotosho bụ ihe sịrị ndị ọrụ nchekwa excuse him out mgbe agbanyụcharala igwe okwu ya bụ microphone ugbo ole na ole. Anyị ga-ekiricha ihe onyinye ahụ niile ebe a. Ya mere asịla na Solex si kama ka anyị lere ọtụtụ ihe onyinyo nke si na ya bụ ụlọikpe wee pụta tata.
I am most grateful, my Lord. My Lord, I am the defendant, applicant, appearing for myself in person, and I most respectfully adopt as my argument in support of this very motion on notice the following processes which I personally filed and served on the prosecution. This motion, my lord, was filed on the 12th day of November, praying this honorable court for the following reliefs. An order referring the substantial constitutional questions raised in this trial to the Court of Appeal pursuant to Section 2952 of the Constitution of the Federal Republic of Nigeria, and an order staying further proceedings pending the determination of those referred questions. The supporting affidavit was deposed to by my younger brother, Prince Emmanuel Kanu, together with all annexures. My lord, my written address filed in support of the motion, wherein I adopted and argued the 3 jurisdictional issues submitted to your lordship for your determination. There was also a further and better affidavit and my reply on points of law filed in answer to the respondent's counter affidavit and written address. My lord, I respectfully urge your lordship to deem all these processes as argued and to grant the reliefs exactly as set out on the motion paper. And in a brief overview of what is contained in my motion, my lord, my contention is very simple. That ab initio, this court lacks jurisdiction to try me, that this very court is a material defiance of an appellate court judgment, the Supreme Court, with specific regards to count 7, which does not exist in the laws of this very country, and which the Supreme Court mandated this very court to amend. That hasn't happened. The presence of count 7 on this charge sheet, my lord, nullifies this entire proceedings completely and totally, because count 7, my lord, does not exist in the laws of this very country. When I reply on points of law, I will make specific references to the ratio that came down from the Supreme Court, where my lord Lawal Garba explicitly stated that count 7 should be changed. That hasn't been done, my lord, and this court is in contempt of the Supreme Court binding order. My lord, the entire argument of the respondent, I'm sorry to say, collapses on just one single point, not many, just one. The Supreme Court pronouncement on the statute of the written law is immovable. It is enshrined in the Constitution of this very country unless a law is written. Unless it is written, defining that very offense, no trial, no conviction can ever take place. And it is my submission, my lord, that this very morning, as we stand in this very hallowed chamber, count 7 does not exist. And not only the repealed laws that will come later. Count 7, my lord, destroys this entire trial. Is it order which wasn't adhered to?
The consultant, you have to go to the defendant to tell him the procedure here. We have the practice of front-loading. I think he has filed his written addresses in support of all this motion. So it's not to repeat what he has stated in his written addresses, but to state the relief is sit for, and just use a minute each in respect of each motion for adoption.
Okay. But he wasn't, they didn't reply to it. I am most grateful, my Lord. I am, without flogging a dead horse, I am asking this very honorable court, my Lord, to please kindly grant my prayers as contained in the motion for reference to the appeal court, and may I also identify the affidavit in support. It is only a 6-paragraph affidavit, my Lord, deposed to by my younger brother, Prince Emmanuel Kanu, also dated the 12th day of November 2025. There is an accompanying affidavit of urgency, which was deposed to by my humble self, also filed on the 12th day of November 2025, and also a written address. My Lord, in support of the motion on notice, praying for the orders I had earlier outlined, that too was dated on the 12th day of November. My Lord, may I most graciously ask my Lord to grant these prayers. Thank you very much.
What about the other 2 motions?
I should move them at the same time?
Yes.
Thank you.
I've made an order consolidating the hearing of the 3 motions.
Okay. The next one, my Lord, is an application, a notice of my commitment to file a final written address, which was dated the 11th day of November and filed on the same 11th day of November. It is accompanied, my Lord, by grounds upon which this very application is predicated, and the grounds are 4 in number, my Lord, and I went on to elucidate the body of objection and then the constitutional foundation and jurisdictional limits of this very court.
Do you have the grounds stated?
Yes, my Lord, you may. Ground number 1, my Lord, states here, the defendant, having called evidence through cross-examination of all the complainant's witnesses, has given evidence and entitled to the summation of those points through a final written address. So I have actually entered my defense, my Lord. What I did not do is to call a witness, because the evidence tendered by the prosecution were surgically demolished. The right to ground 2, my Lord, the right to final address is a fundamental constitutional right integral to fair hearing under Section 36, Sub 1 of the 1999 Constitution, and no court had jurisdiction to unilaterally order its waiver without the express, informed, and voluntary consent of the right holder, which is myself. The third ground, any order directing or implying a waiver or final address constitutes a breach of fair hearing, my Lord, which goes to the root of the court's jurisdiction and renders the entire proceedings a nullity. The court, ground number 4, the court lacks jurisdiction to extinguish or dispense with mandatory procedural stage of criminal adjudication, such as a final written address, as this would amount to an unlawful assumption of power beyond the limits prescribed by the Constitution and extant laws. And ground number 4, for reference purposes, my Lord, Section 36(1) of the 1999 Constitution, which I'm sure the court has taken judicial notice of. Those are my grounds, my Lord, in respect of the notice, seeking this court's discretion to allow me to file my final written address. Having entered my defense, I move that this very notice be adopted, my Lord, in its entirety. The third third and the very last one is the issue of bail. My Lord, the issue of bail. This was dated the 17th day of November 2025 and filed on the 17th day of November 2025. It's a very simple one. It is a notice, my Lord, brought pursuant to sections 35(1), 35(4), and 36(12) of the Constitution of the Federal Republic of Nigeria, 1999, as amended, sections 158, 162, and 165 of the Administration of Criminal Justice Act 2015, and under the inherent jurisdiction of this very noble court, I am praying, my Lord, for an order admitting me on bail, the defendant applicant to bail on liberal terms, pending the determination of the invalid charge presently before this court, an order, my Lord, declaring that the continued detention of the defendant applicant, my humble self, in the absence of a valid subsisting charge under a written law in force, is unconstitutional, null and void, my Lord, and for any other orders that my noble Lord may deem fit to make under the circumstance. This is supported by an affidavit of 9 paragraphs deposed to by Prince Emmanuel Kanu, and also by a written address which I urge, my Lord, to accept its adoption. Honorable Lord.
Yes. You moved the 3 applications?
I have, my Lord.
Thank you.
Thank you.
The prosecuting counsel, can you react to those 3 applications?
May it please your Lordship. The prosecution filed reply to the first motion on the 14th of November 2025. We also filed a reply, a counter affidavit and a reply in respect of the first motion. For the second motion, we also filed a reply all on the 14th of November 2025. For the third one, for the further application for bail, we did not file any counter affidavit. So for the first one, sir, I respectfully adopt the counter affidavit of the prosecution and the written address. And we urge your Lordship to dismiss the application because it's a regurgitation or repetition of the well-worn argument that the counts which the defendant pleaded to were unknown to law. It is for your Lordship to determine that in other ones. But the one asking for stay of proceedings, my Lord, our argument is to the fact that the statute does not permit your Lordship to grant any stay of proceedings or injunction. So we ask your Lordship to dismiss it. And for the second, we also filed a written address dated 14/11. We adopt it with all respect, and we urge your Lordship to dismiss the application as lacking in merit. For the last application, asking for the defendant to be admitted to bail on the same ground that, the counts to which he pleaded not guilty were unknown to law. Again, is a repetition of the old argument. It is for Lordship to determine whether the laws were valid, whether his plea was valid, and whether he is answerable to the law when he committed the terrorism acts. The terrorism acts he committed was...
Please,
So we urge your Lordship to dismiss the application. On the other ground is also to the fact that the applicant has another pending motion filed in March, in April 2025, asking for the same relief, bail. So the latter bill, the latter application with respect, is an abuse. In any event, none of them merits. We urge your Lordship to dismiss it.
Please, let's save the time of the court.
We are praying your Lordship to dismiss all the applications because they lack in merit and do not deserve any consideration at all. Thank you, my Lord.
Thank you, sir. Defendants, you have one or two words to say?
Certainly, my Lord, and I'm most grateful. My point is a very simple one, my Lord. Very, very simple. My charge sheet, as presently constituted, does not reveal or disclose any written law in Nigeria as at this very morning.
Thank you.
It doesn't exist, my Lord. And very finally, I think it is very, very important that I allude to what my lords...
Please, defendants, at this point, you won't go and make references. I just ask you to reply on point of law.
It is, my Lord. I'm trying to explain exactly what the point of law is all about. We respect what you have just said.
Yes, let me hear the point of law.
My Lord, I cite Eze v.
I'm coming. Consultants, you may guide him properly. Thank you. Let the consultant sit with his client. Or do we have all the consultants? Do they want to sit with their clients? Okay, let me see. Are you here? Mandela, you're here. Okpara is okay. Where are the others? Ejiofor, where are the others? Yes, you just have 2 minutes for this.
And be granted. Once it is a jurisdictional matter, stay can be granted. What I'm asking for is for a referral, my Lord, to the appeal court for the determination of these very key issues. And also, I reiterate that AJA is not superior. It is not superior to the Constitution of this very country and an established jurisprudence as determined by the Supreme Court that stays can be invoked insofar as the issue borders on jurisdiction. And my Lord, this is very, very critical. Not minding anything we may have said before, or I may have said, the fact of the matter is that the very count 7 laid under Criminal Code Act Cap C45, my Lord, is not Nigerian law. It doesn't exist. It just doesn't exist. Why should I be in detention over charges that don't even exist, my Lord? It doesn't.
You are exceeding the 2 minutes.
Okay.
Can you
Just,
summarize?
yes, please. I ask, my Lord, that I be granted bail on very favorable terms, given that a concurring judgment of the Supreme Court of Nigeria determined, my Lord, and found that I did not jump bail. I never did. That was their finding. I did not jump bail. And that the revocation of my bail implied that.
It's okay.
Thank you, my Lord.
Thank you.
That's it.
You may sit down. I'm going to read extempore as the application and fall before these courts. The defendant filed 3 applications after the matter was adjourned to today for judgment. The defendant filed a motion on the 17th day of November 2025, seeking for 2 reliefs. 1, an order admitting the defendant's applicant to bail on liberal terms pending the determination of the invalid charge presently before this honorable court. The second relief is for an order declaring that the continued detention of the defendant applicant in the absence of a valid subsisting charge under a written law in force is unconstitutional and void. The second application is the motion on notice dated and filed on the 12th day of November 2025, seeking for 2 reliefs. The first relief, as stated in this motion, is an order referring certain substantial constitutional questions arising in this trial to the Court of Appeal, pursuant to Section 295, Sub 2 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. The second relief is an order staying further proceedings in the charge, pending the determination of the referred questions by these courts to Court of Appeal. The third motion has to do with the notification to file written address. As defendant stated, he has put in his defense as his right to file written address should not be taken away from him. I've considered also the processes filed by the prosecution in reaction to some of the motions. In the application seeking to refer some questions to the Court of Appeal, the defendant submitted inter alia that the court cannot proceed to give judgment on a defective charge not founded on a written law, and that the court cannot rule on count 7 of the charge, contrary to the decision of the Supreme Court. I must say, most of the issues raised here in the application, save the application for bail, have been raised by the defendants severally in these courts. And these courts has made an order that all preliminary objections or issue shall be taken during the judgments. This court is bound by that order. However, the issue as regards to referral of questions to the Court of Appeal and the stay of proceedings the statutory law governing criminal procedure in Nigeria, to wit, Administration of Criminal Justice Act 2015, by Section 306 of that Act, which provides that an application for stay of proceedings in respect of criminal matters before court shall not be entertained. These statutory provisions was initiated by the Court of Appeal in the case of Shuaibu versus Federal Republic of Nigeria. I must speak as to the essence, the reason for this statutory provision, that is Section 306 of Administration of Criminal Justice Act. The essence of this provision is to prevent inordinate delay through the filing of appeals while trial is going on. For this reason, the Section 306 of Administration of Criminal Justice Act having provided that such application shall not be entertained, this court shall not entertain same. As regards to the application seeking for bail, we have different types of bail applications. Bail application can be bail pending trial or bail pending appeal. I've looked at the application for bail. This application before this court does not fall within those two classes of application for bail. In this matter, as also stated by the defendant, that he has put in his defense. Hearing has been concluded. And also, by the order of these courts, on the 27th day of October 2025, the court made an order that the defendant should next date put in his defense, or if he's not putting his defense, he should file address which shall be deemed to be final address. The defendant's portion to that filed motion and comprehensive address. It is based on this that I hold that issues are relieved is highly unmeritorious. Same is hereby dismissed. Like I said earlier, all other issues have been raised through that motion and comprehensive final address that was deemed as final address, and another motion filed thereafter. These courts, in the interest of justice, will not close its eyes to see. The court will determine all these issues in its judgments. I proceed, I deliver my judgment. Judgment, please.
My Lord, I have an objection. Final written address is a constitutionally mandated right which I must be granted. It is in the constitution of this very country that final written addresses, my Lord, must be granted. I have not waived it, my Lord, and I insist that I address this court on all these issues. My Lord, do not forget.
The defendants?
My Lord.
Consultants, can you tell your...
My Lord, I will not, please, let me finish.
Please.
It's my case.
I've gone...
It is my case, my Lord, let me finish. My Lord, this very court, another idea that FAN was here, my Lord, another idea that FAN said, at the one time we will contradict and provide a piece of evidence. A piece of evidence given to the court. I need to write my comment.
Please.
Show me where it says and tell me on the big law. Show me.
Please, get the microphone from him, please.
I said, show me. Show me.
Excuse me.
Show me.
Get the microphone from him.
No, leave it. Leave it. Leave it. I said leave it. It's a court of law. I'm under trial. I'm under trial. I have to speak. I'm under trial and I have to speak. Listen to me. Listen to me, please. I'm under trial. I'm under trial.
Please use the microphone.
I'm under trial. And I must address the court. Please. Wait. No, listen to me. Please. The judge must listen to me. No. Wait. Wait. I'm asking a very simple question. No. Wait. Please. Look, this is Supreme Court. Wait, hold on. This Supreme. You cannot show me. I'm a judge. You can't be a judge. You don't know law. You don't know law. Smart people. You don't know law. Don't touch me. Don't touch me. That's idiot. That's the fool. Don't touch me. Don't push me. I'm going. Don't touch me. I'm warning you. Don't touch me. I'm warning you. Don't touch me. Don't touch me. Don't touch me. I said don't touch me. Don't. Smart people. You don't know law. Show me where it says you can wear my right foreign address. Show me the law. Show me the law. I want to show me the law. You don't know law. They are demoting you. You are writing rubbish. Show me the law. Unaddressed affidavit. You say you were giving their job for them. I'm going to punish you. Now and forever. Any judgment, let it be on record. Any judgment given in this court is rubbish. Ask him where is the law. Ask for what show. Where is the law? Where is the law?
ọkụ ihụla nke ahụ onye sị gị na ịgụ akwụkwọ adịghị mkpa si onye ahụ na okwu asị onye ọbụla sị gị na skuul bụ skam si onye ahụ na onye ọ nyere anyị nwanne anyị nwoke a bụ Mazi Nnamdi Kanu. Onye ahụ bụ mmadụ iri n'ihe gbasara agụmakwụkwọ na amamihe. Ọ dị mma ka anyị gere etu olu ya bụ onye ọkaikpe bụ Justice James Omotosho maka na ihe onyonyo live video anyị gosibụrụ n'ehihie ya bụ live video karịchara awa 3. Ọtụtụ okwu ya bụ James Omotosho kwuru nọ ebe ahụ maka ndị chọrọ ịnụrụ ya, ma ebe anyị ga-enyo anya na nkenke oge ugbu a na ya bụ ebe ya bụ Justice James Omotosho nọ wee ma Mazi Nnamdi Kanu ikpe. Ka anyị lere ka ya bụ ihe si wee gaa. Ikiricha ya bụ ihe onyonyo idera ebumnuche gị otu si ahụ ihe niile gara n'ụlọ ikpe tata. Ụmụnne m ka emesịanụ.
With mercy. The court is moved by chapter 23, verse 23 of Matthew in the book of Matthew, to the fact that who unto you, scribes and Pharisees, hypocrites, for you pay tithes of mint and anise and cumin, and has omitted the weightier matter of the law, judgment, mercy, and faith. This you ought to have done, particularly, and must notice the words in Matthew 23 and verse 23, the word mercy. Our Lord himself is merciful. No matter what we do, he is a merciful God. It is on that note that the court will follow this above admonition of Jesus Christ in the above passage and show mercy to the convicts. In addition, the death penalty globally is now being frowned upon by the international community. Consequently, and in the interest of justice, I hereby sentence the convicts to life imprisonment for the said counts 1, 4, 5, and says, instead of death sentence, life is sacred to God. With respect to country, he is hereby sentenced to 20 years imprisonment without no option or fine.
That's your prisoners. Abby?
Yes, sir. So we would just like you to react to the judgment just delivered. Please, sir, just...
It's a day of joy. Now, gentlemen of the press, you know, since we'll trial, yes, men, because the profession does not allow me to what happened to the inner works of the court. The law does not, the profession does not allow me to tell people what happened in court. But today, we have come to a final end. Justice has been done. And therefore, Nigerians must, one way or the other, appreciate the judiciary. You remember just last Monday, the president was saying, at any time when Nigeria is in a big trouble or fix, judiciary has always come to the aid to salvage Nigeria. Again, the judiciary has salvaged Nigeria from the claws, from the oppression of the proscribed IPOB. The court has also pronounced death sentence on Eastern Security Network, which was the military wing of IPOB.
Judgment that has just been delivered. After been a long battle from 2015 to now, but your client got life imprisonment. How are you going
Well, today we forever live in. Today is the only day I have witnessed a man being convicted for mere puffery, for what he said from his mouth, not what he did with his own hands. The verdict is not consistent with the evidence laid before the court. The sentence is overbroad, cruel, and unusual. How can you convict a man for making mere broadcasts from a location that was never named, and he never tied that broadcast to any single incident of violence, or even someone slapping someone, not to talk of terrorism? You did all this. Nobody is going to trample on me. Nobody is going to trample on Nnamdi Kanu. Mazi Nnamdi Kanu is not a terrorist. He's a man that was pursuing change. To pursue a separate nation of yours is not a crime. So in Nigeria today, if somebody says, don't be silly, you get convicted. Mazi Nnamdi Kanu may broadcast, and so what? And you convict him for terrorism, for mere words in the Federal Republic of Nigeria. What kind of precedent is being laid? So from here, we are heading to the Court of Appeal. The Court of Appeal is the only court in this country, or the next court in this country, that sits as a jury. We are going to approach the justices there to check out what happened in court today. And we are pretty sure the justices will agree with us that today was the symbol of the travesty of justice that everybody has been suspecting all along. If the Court of Appeal disagrees with us, we head to the Supreme Court. But by God Almighty, Mazi Nnamdi Kanu is not going to stand convicted. Is going to get overturned. Thank you.
Excuse me.
Thank you.
Please, I want you people to get something right. I want you people to get something right. First of all, I want to talk to the Igbos that nobody should take laws into your hand. I'm assuring you, this judgment is predicated on our anger. Thank God that the judgment was extreme life and everybody watched it. You will see the anger in delivering the judgment. And it's not predicated on law. Now, I also want to let you know that this charge, that the investigation that gave rise to this charge was not investigated. Because Mazi Nnamdi Kanu said statement, purported statement, was rejected by this court. And they did not tender any document as investigation report. That is to say, the investigation was not, the offense was not investigated. Having said that, also something that happened in court today, Mazi Nnamdi Kanu filed a matter in court of appeal, and he is asking my lord, that particular matter I filed in court of appeal anchored on this particular issue. Please, can you just suspend this judgment? Let court of appeal direct what to do. My lord refused. Now, on the issue of anger, you journalists will bear with Mazi Nnamdi Kanu that government, Nigerian government, and the judiciary are not fair to Mazi Nnamdi Kanu. What do I mean? Nnamdi Kanu was given judgment by court of appeal.
Ebe a bụ ebe onye ọkaiwu barista Maxwell Opara ka na-ekwu okwu ka o rutere ọ dịka ihe nwa na-eme ikuku mgbasa ozi ndị channels ebidokwala, mana unu ahụlanụ ka ya bụ ikpe si wee gaa tata, ma onwezi onye a ga-akọrọ ka ya bụ ihe si wee mee. Gị bụ onye na-ekiri ihe onyonyo a, deere ebumnuche gị otu si wee hụ ihe niile gara n'ụlọ ikpe tata. Deere anyị na ngalaba okwu ka anyị mara uche gị, n'ihi na uche onye adịghị ya njọ. Ọ bụrụ na ị na-ekiri na YouTube, ị chọọ ikiri ihe onyonyo live video nke anyị meburu n'ụtụtụ mgbe Justice James Omotosho na-agụpụta ọtụtụ ihe niile ọ gụpụtara, aga m etinye ya bụ ihe onyonyo na YouTube. Aga m ewepụta ya na Facebook tinye na YouTube. Ụmụnne m, ka emesịanụ. Chukwu gọzie Mazi Nnamdi Kanu.